Hi everyone, welcome to the PEB channel. My name is Joel Pettit, and today I want to talk to you about a disturbing trend when it comes to early separations in the IDES, specifically ELS, so entry level separations, and individuals who are being pushed out through essentially an administrative separation, vice going through the DES. And the biggest issue I see are commands who somehow think that the rules don't apply to them. And what I mean is they see ELS, which is governed by DoD instruction, so DoDI 1332.14, and there is no specific paragraph or chapter on ELS. It is peppered throughout the whole instruction. So that is not, it's not conducive to really understanding ELS because you have to read the entire instruction. But if you want to, that is the way to really grasp ELS. Also, your service will have specific instructions concerning ELS and updates and things of this nature and how they use it. That being said, it can be very complex, but what I'm talking about isn't, and that's what's so, well, I'd say pathetic about this, that what the commands are doing is if someone gets hurt during training to the point that it could be a disability, they are supposed to attempt to heal that individual, if you will, and if they can't, and could be a disability, then refer them into the DES process. Of course, I'm oversimplifying this. However, what they're doing usually is simply trying to administratively separate that individual. Although that's not correct, the biggest issue I have with it, morally and ethically, is the process they're using. Because over the last few months, what I've seen are commands that tell individuals you are not meeting standard because of X. And X is usually an injury with symptoms that persist that are stopping that person from continuing training. Well, instead of counseling that individual and then giving them access to the records that, the medical records that have the data, the results, the things that the commander is using to say, these are the reasons you're not meeting standards, they're basically saying, no, you don't get to see that. And I'm usually not this blunt, but the stupidest reason I've heard is the hospital owns the records. That really just means screw you, go away. That's what it means, because it doesn't mean anything else. In the medical record world, the hospital doesn't own records. It doesn't work that way. You own your records. The hospital owns nothing. They are record keepers, but they do not own records. The only time they can refuse to give a service member his or her records is during very, very limited exceptions. And usually those exceptions apply to mental health cases when releasing the records to the individual may cause that individual to be suicidal or homicidal. Even then, if you want your records, you can request them using a DD 2870, and you can designate a person who will not become suicidal or homicidal to receive those records, such as a legal representative, family member, or friend. So that being said, what I need you to understand is if someone tells you they cannot give you a copy of your records, that's a HIPAA violation, because it is. Most of us understand HIPAA as the right to not have people publish your information, or just give it away. Well, that's half of HIPAA. The other half is if you have records within a covered system, and being a military member, you would, they can't say no to giving you records except in those very narrow exceptions. So when a counseling that's pushing you out of the military is based on those records, and the command, they're not allowed to get those records. They're not. They're allowed to get summaries of tests and things like that because they have to know about the health and welfare of their members. And again, I'm oversimplifying, but they can get that type of record. However, they cannot stop you from getting your records. So in the Marine Corps, the Navy, you can do you can have request mast. You can rebut a 6105 as a counseling you get. All the services have something like this. However, you must understand that for some reason, these commands, they don't care. They're just not caring. And it's just appalling, because I've recently had a few commands that basically are daring the members to sue them because they know that this person's a 19 or 18-year-old individual. They don't have the resources to fight back, and they are blatantly violating HIPAA. And not just the commands, or I should say the training command, but also hospital staff. So these are ongoing issues that I'm dealing with, some of my clients are dealing with, but you should be aware that HIPAA goes both ways. So if someone says you can't get those records, or somebody owns those records, it's crap. It is not true. It's a lie. There may be a processing time. There can be up to 30 or 60 days sometimes. So yes, they have time to process them. But when they say you can't get them, that is a bold-faced lie. So if you're facing this kind of situation, please go to my website, joelpettitlaw.com, shoot me an email, give me a call. I'd love to speak to you about your potential case. Thanks for watching, everybody, and have a great day.